Ms. Mdluli, you've prepared a statement which, in relation to the evidence you're going to give before the Commission, is that correct?
Press once, Ms. Mdluli.
Through you, Mr. Commissioner, yes, it is correct.
Were you compelled to prepare the statement?
No, I wasn't compelled.
And were you compelled by the evidence leader team to put things in your statement which you did not agree with?
No, I wasn't, Mr. Commissioner.
So the evidence you're going to give to the Commission relates to the VBS transaction, is that correct?
That is correct, but it's with relation to the 350 million rand facility as well as the rights issues.
Okay.
Thank you.
Let's proceed with your statement, starting from paragraph 1.
Mr. Mahapi, can you arrange for her mic to be closer to her, please?
Okay, I, Brenda Buyisiwe Mdluli, an adult female, confirm that the contents contained in the statement are within my personal knowledge and are to the best of my knowledge true and accurate. By way of my education and work experience, I have obtained the following qualifications: a Bachelor of Commerce degree majoring in Corporate and Investment Finance, Business Information Systems and Information Systems Technology from the former University of KwaZulu-Natal. I have a higher diploma in tax law from the University of Johannesburg, a certificate in advanced company law from the University of Witwatersrand, and I am a FSCA certified FACE representative. My working career started in 1999 as an administration assistant working for a company called Tegwini Business Development Center, currently known as SIDA at Tegwini, that assists small businesses with business advisory services. I moved through the ranks to my last position as a Senior Business Development Officer. In 2005, I was appointed as a Portfolio Assistant at Umsobomvu Youth Fund, which is currently known as the National Youth Development Agency. And I started as a Portfolio Assistant, and then I was promoted to an Investment Officer in 2006 and 2010. And then in March 2010, I was appointed as a project manager at the PIC. And then from being a project manager, I was promoted to an investment associate and have been an associate principal since November 2016.
You started off in the Isibaya Fund.
Isibaya Fund, correct, Mr. Commissioner. I have been an employee of the PIC since the 15th of March 2010, with uninterrupted service, holding various positions within the Isibaya Fund Impact Investing Division. I'm currently an associate principal within the Impact Investing Division. I have been requested by the Judicial Commission of Inquiry into the PIC to make a statement detailing my role, responsibilities, and involvement in the PIC investment in the VBS mutual bank transaction.
Just before you get into that, associate principal, impact investing.
Correct, Mr.
What's the nature of your work there?
The nature of our work involves screening of transactions, compiling or reviewing appraisal reports, presenting them to a committee and recommending them for approval to a committee.
And those are things that you did in relation to VBS, is that correct?
That is correct.
Okay.
Can you, maybe for clarity, give a bit of a pecking order from, say, the analyst up until to the highest point?
Okay, it's the analyst, it's the investment associate, it's associate principal, then it's the fund principal.
The fund principal.
Yes.
So you are in the sort of second most powerful position before the executive head. Is that correct? No?
I wouldn't say most powerful, I would say...
Second, I said, second most powerful. Okay.
I'm not sure about powerful, say.
Oh, okay.
Yeah, that's
All
that's
right.
the one
Okay.
that I'm not sure
Let's
about.
leave it there. Yeah. That's fine. That's fine.
Okay. If I move on to the outline of my statement covers the following. Number one, my involvement in the 350 million rand revolving credit facility advanced by the PIC to VBS. That is termed the facility in my statement. The review process of the facility. Number three, whether the approval conditions of the facility by the priority sectors, small and medium enterprises fund investment panel, included the following provisions that are in the facility agreement. There is clause 3.5, which reads as follows. The facility shall be ring-fenced for its purpose as defined in the agreement, as shall be subordinated as against other creditors or borrower creditors. And clause 3.6, which reads as follows. The facility outstanding amount or any portion thereof may be converted into equity at the discretion of the lender at any time before the final repayment date.
While we're there, Ms. Mdluli, can you just explain the concept of ring fencing?
Basically, ring fencing is protecting an asset and you segregate it to be separate from the normal operations of the existing operations of the bank, so that you will always have control of the money that is going for that facility. I don't know if that is clear.
Okay, we can proceed. We will explore that further in your statement.
For my purposes, because I don't know much about investing, what is a revolving credit facility?
A revolving credit facility means you have access to the facility, and once you've used it, you will have access to it until it's top up, but it cannot be more than 350 million. Every time you use it, you have to repay to retain it to the 350 million that it was approved.
So the way it works is there's a drawdown on this total amount that you have at your disposal, and you have to repay it, and at that, it always has to stay at the maximum of 350 million.
Correct.
Is that correct?
Correct. Okay, can I continue? Okay. Okay, my involvement in the transaction relating to the facility. I got involved in the transaction relating to the facility on or about March 2014. The facility was approved as a ring-fence revolving credit facility to be utilized to fund VBS's contract financing book, which form part of VBS strategy to diversify its product offering and revenue-generating activities by introducing new products. The application for the facility was first introduced to me, or to myself, by Mr. Paul Magula, who was then the associate principal of unlisted debt within Isibaya Fund. And he was also an alternate director to Mr. Nesane on the board of VPS, and was also my senior in this instance. Because at the time of this transaction, I was still occupying the position of an investment associate, not associate principal.
So they sit on the VBS board, that is Mr. Magula and Mr. Nesani, by virtue of the PIC having shares in the bank. Is that correct?
That is correct, Mr. Commissioner. As a standard at the PIC, the first internal step in a transaction is to compile a scoping report. The scoping report in respect of the facility was compiled by Mr. Paul Magula. Given that Mr. Magula, although my senior, was at the time new in the division, he required assistance in understanding the processes and the structure of the report. My colleague, Ms. Kinti Yende, and I assisted him by reviewing the scoping reports in respect of the facility. On the 13th of May 2014, the investment team, which was comprising of Mr. Paul Magula, myself, Brenda Mdluli, and Ms. Kinti Yende, attended the first Portfolio Management Committee unlisted meeting and presented the scoping reports in respect of the facility. The meeting approved the scoping reports in respect of the facility and authorized the team to proceed with an internal due diligence investigation, meaning that the due diligence process would be conducted by internal PIC personnel. During May 2014, Mr. Makula compiled the appraisal reports also, and he was the person who was responsible for the collection and collation of information and all the interactions with VPS.
Just to stop you there, Ms. Mruli, when he was acting in this capacity and preparing this appraisal report, was he already sitting on the VBS board?
He was an alternate, if I remember correctly, he was an alternate director to Mr. Nesane
Okay.
at the time.
Okay. All right.
Okay, during May 2014, Mr. Magula compiled the appraisal report. Okay, upon conclusion, of the appraisal report, Mr. Makula requested us to review his appraisal report. Notwithstanding the fact that I only reviewed the appraisal report, Mr. Makula designated me as a compiler of the report. And the appraisal report was presented at PMC on the 29th of May 2014. Thereafter, the transaction was recommended for approval by the PS SME FIP on the 24th of June 2014. And on the 24th of June 2014, the PS SME FIP approved the facility based on the conditions, and there were conditions set for the facility, which I would like to make a correction, Commissioner. I will refer to point 18 of my statement, not point 14.
Okay, that's paragraph 18.
Yes.
Thank you.
And then on the 1st of October 2014, Mr. Makula was then appointed as the acting chief risk officer and moved from the Isibaya Fund to the risk division. As he was the investment team lead at the time, I was expecting that Mr. Makula was going to continue with his role in finalizing this transaction after the PS SME FIP approval, but instead he went silent and did not respond to email requests for comments on the legal agreements that were sent through by the then legal representative, which was Mr. Ernest Nesane.
Let's proceed, paragraph 14.
Okay, paragraph 14, it's in relation to the review process of the facility. Clause 18.1 of the revolving credit facility agreement that was signed between the PIC and VBS reads as follows. The facility is subject to review on an annual basis. The lender is to be provided with a copy of the borrower's audited financial statements, which are to be provided within 6 months after the borrower's financial year end. The PIC Portfolio Management and Valuations Division undertakes the responsibility of facility reviews. I was involved in facilitating the flow of information between the PMV division, in this instance, my former colleague, which was Yolanda Makwenji, who is no longer working for the PIC, and Mr. Kaya Zonke, who's currently at the PIC, were the personnel who were leading the facility review process in VBS. For ease of reference, I have attached email communication to confirm the information flow facilitation marked as Annexure A.
So your Annexure A is constituted of a series of emails and documents which were part of that process. Is that correct?
Correct, Mr. Commissioner.
Okay, let's proceed, paragraph 16.
Okay, I cannot confirm how the PMV undertakes the review process. The PMV team is best placed to respond to the issue of the review process and compliance therewith, as they are the ones who were responsible for the review process of the facility. I can confirm that I did not see the review report, and I was not expecting to see the report, as it was supposed to be an independent review, which is independent to the investment team, and it was supposed to be presented at PMC.
Just taking a step back, Ms. Mdluli, the relationship between the PIC and VBS, since you're the first witness testifying on VBS, as I understand it, VBS was a legacy investment. Can you explain that to the Commission?
On the legacy issue of VBS?
Yes, so it was an inherited investment.
Yes, it was.
As I understand it.
Okay, I'm trying to find it. document that talks to that.
Or to put it simply, the PIC had a pre-existing relationship with VBS where it had inherited basically
Yes, it had.
this investment.
The government pension fund of vendor was a shareholder in the vendor building society. And then the PIC became a shareholder of VBS Mutual Bank with the enactment of the Government Employees Pension Law, which was enacted in 1996 on the 1st of May 1990. And Section 14 of the GEPF law provided for the discontinuance of the government pension fund of vendor as well as the government superannuation fund of vendor, and for these funds to be amalgamated into the government employees pension fund. So this is how PIC inherited the VBS Mutual Bank transaction. So it was an existing client of the PIC by that enactment.
What are you reading from?
It's just
Information that you've just read into the record, you're reading it from what?
It's from my notes that I prepared, Mr. Commissioner.
Your own notes that you prepared.
Yes, Mr. Commissioner.
Is there perhaps a document which we can source which would have that information and which we can then provide to the Commission?
Yes, I think we can provide it to the Commission.
I confirm, Mr. Commissioner, that we will provide that a document that gives the background of the relationship between the PIC and the bank.
I'll appreciate that. I know I also read it somewhere, but I can't remember where. All right.
We will provide it to the Commission.
Okay. And then the approval conditions of this facility. The facility was approved on a ring-fence basis, as mentioned, to ensure that it was operated separately from other product offerings by VBS. The conditions of the approval of the facility by PMC and PS SME FIP did not include the following revised or amended underlying conditions which were included in the facility agreement post the approval.
So just to be clear, the parts in your statement which are to follow, which have been underlined, are things which were inserted post-approval?
Correct, Mr. Commissioner.
Okay. We can proceed. And then when you just mentioned the parts which are underlined, you can just mention that these are things which are now underlined for the record.
Okay, I'll do that. The clause 3.5, which reads as follows: the facility shall be ring-fenced for its purpose as defined in the agreement. As the part that is underlined is the part that was not part of the approval. As such, shall be subordinated as against other borrower creditors. And the second clause was clause 3.6, which reads as follows: the whole clause was not part of the approval. The facility outstanding amount or any portion thereof may be converted into equity at the discretion of the lender at any time before the final repayment date. And the legal department personnel at the time who settled the draft facility agreement would be best placed to explain the rationale for the inclusion of the above clauses.
Can we just spend a moment on these clauses, Ms. Mdluli? So the first part of clause 3.5 talks about ring fencing the facility.
Correct.
Then the second inserted part talks about as such shall be subordinated as against other borrower creditors. That's a contradiction in terms, isn't it?
According to my understanding, I don't think you can ring fence a facility and at the same time subordinate it, because it's supposed to operate separate from any other creditors or any other operations of the bank.
So with what has happened to VBS, the idea with ring fencing was to protect the loan, the facility given by the PIC against VBS's other creditors.
That's correct.
The fact that now it's been subordinated has deprived the PIC of that protection, hasn't it?
That is correct, Mr. Commissioner.
And also in relation to clause 3.6, to convert the facility into shares is also a contradiction in terms of the ring fencing, isn't it?
And that was not the intent of the facility in the beginning. Even at approval, no one talked about the facility being converted into equity.
Thank you, Ms. Mdluli. Let's proceed. Paragraph.
Just to double check, so 6A, 6.3.A is that, so the problem is there is that you have done the is the subordination part. The second one, it looks like it reads the same kind of wording, yeah? It's correct, but it was not supposed to be convertible.
Yes.
And this point wasn't in the shareholders, in the agreements. Is that?
This point was in the facility agreement, but it was not part of the approval conditions that were approved by the fund investment panel.
Yes. Which part is this now? The 6.3.B, 6.3B.
There is a, okay, it's 18 and it's B of my statement, but the clause is clause 3.6 in the facility agreement.
Okay, all right, okay, all right.
Okay. On the 13th of April in 2015, an email addressed to myself and Mr. Makula was received from Mr. Nesane requesting us to comment on the facility agreement, which was attached to the email before it could be issued for signatures. I then printed that version of the document to read through and wrote down my comments on the printed hard copy version. This version of the facility agreement did not contain the two clauses mentioned above, which is clause 3.5 and 3.6. For ease of reference, a copy of the emails have been provided also to clarify that statement.
Sorry, just for clarity, Ms. Mdluli, when we refer to clause 3.5 and 3.6, we're referring to those clauses in the facility agreement.
Correct, Mr. Commissioner.
Okay, thank you.
And then on the 23rd of April 2015, an email was received from Mr. Nesane again addressed to myself and Mr. Makula with two attachments now, which were the facility agreement and a section of underlying contracts agreement. He indicated that these documents were execution versions and requested us to comment or recommend changes before signatures. On receipt of this email, I realized that I had not sent my comments earlier as he had requested, and I had already written in my hard copy printed agreement the comments that I wanted or the changes that I was recommending to the agreement. And then on the afternoon of the same day, which is the 23rd of April 2015, I sent a response email to Mr. Nesane by working through my handwritten comments on the hard copy printed document that I had printed. I was under the impression that the document that I had printed was the same document that I received on the 13th of April 2015, as Mr. Nesane did not mention that there were any material additions or changes to the first document that he had sent or that we received. The document that I emailed back to Mr. Nesane with my comments had clauses 3.5 and 3.6. I think I might have missed the insertion as I was working from the printed hard copy document without these clauses. A copy of the email is also provided for ease of reference.
Just to interrupt you there, Ms. Mdluli, so if you can just take the Commission through the process of putting together agreements in the PIC, there would have been an investment approval process.
Correct?
You would have resolutions for approving the investment,
That's correct.
and those have to be incorporated in an agreement, and it's the legal division's responsibility to incorporate those into the agreement.
That's correct, Mr. Commissioner.
Okay, thank you.
Happy. Reference is made to a copy of an email provided for ease of reference. Where is it? Is it one of the annexures?
Which,
There's another one before this, another copy of an email. And there's no annexure reference for it.
The emails have been provided to the Commission separately to the annexures, Mr. Commissioner. We thought it best to provide them as they are electronically, but they have been provided to the Commission and will be made available.
I was not aware and cannot confirm when the clauses 3.5 and 3.6 were added to the agreement until at a very later stage during the announcement of the decision to place VBS under curatorship in March 2018. And an additional condition which was part of the resolution from the PS SME FIP was that the facility drawn down will be such that 200 million rand will be drawn initially and the 150 million rand to be made available in line with the performance. I can confirm that this condition was not included in the facility agreement. I cannot confirm that I was not aware of this, but I assume that as the disbursement was done in tranches, this condition was fulfilled.
Could I ask you, given the amount of documentation flow in different versions, does the PIC have a methodology by which all of you follow to know which version you're on and who has seen and signed off and approved which version, so that you know you're on version 7 and XYZ have all seen it and ticked yes, this is, so we're all working off the same page and I'm not on version 1 and you're on version 3 and somebody else on version 7? Do you have a methodology that is followed in all the departments, including your own, that allows the tracking of which version of what document and who has seen it as a matter of course?
Through you, Mr. Commissioner, I don't think we have a system or a process that talks to that. But the person who is in control is the one who will either be sending you information or sending you the documents. They will have the original document and they will have all the review documents as well. Can we just look at that as going forward? Because if this is applicable, not applicable here, elsewhere in the organization, otherwise you don't know where you are in terms of what is being finally agreed. People will have a different understanding of what has been finally agreed if you're not working off the same document or same version of document.
But just in relation to the Commission's question on this aspect, it would have been Mr. Nesani's responsibility to ensure that the finally adopted document has all of the relevant approvals and that it's the correct document that would be executed upon.
That is correct, Mr. Commissioner. The legal representative is the one who's the ultimate responsible to making sure that whatever is in the legal agreement is as per the resolution or as per the approval by the fund investment panel or the committee that approved the transaction. And then paragraph 25 is in relation to the process that was followed, which resulted in the PIC participating in the second and the third rights issues simultaneously. On the 8th of May 2017, I received an email from Mr. Philip Truter, who was the CFO of VBS, addressed to my colleague, Ms. Lufuno Nechuketa, and I. The email contained a notice to the shareholders of VBS dated the 28th of April 2017, stating that the Board of Directors of VBS had resolved to extend the deadline of the second rights issue up to the 31st of May 2017. The initial notice of the second rights issue was not sent to me, and to the best of my knowledge, was also not sent to anyone at the PIC. This notice, the initial notice of the second rights issue was allegedly sent to the shareholders around August 2016. As the initial notice was not sent to the PIC did not participate in the rights issues of August 2016, and this had the effect of diluting PIC's shareholding in VBS from 25.26% to 11.96%. I contacted Mr. Truter immediately to understand the contents of the second rights issue notice that was contained in the email of the 8th of May 2017, as there were no records of receipt of the initial notice of the rights issue by the PIC as a shareholder. I also sent him emails to that effect. I stated in the emails that the PIC should be given a fair chance to also undergo the internal processes of making a decision of whether they are participating in the rights issue or not. The PIC team, which was myself, Brenda Mdluli, Lufuno Nechikweta, Kaya Zonke, and Yonga Mamelapi of PMV, requested a meeting with the VBS CEO, which was Mr. Andile Ramabunga, and the chairman of the board of VBS, which was Mr. Chifiwa Matodzi, to discuss the participation by PIC in the second, extended, and the third rights issue. On the 26th of May 2017, VBS had a board meeting at the Indaba Hotel in Fourways. During the break of that board meeting, the PIC team held a meeting with the VBS CEO, chairman of the board, and the CFO. The PIC team advised the VBS colleagues of the PIC standpoint with regards to the unfairness of the process that would lead or led to the PIC shareholding dilution.
Just before we move on, Ms. Mdluli, was the PIC, was this team constituted of yourself, Lufuno, Kaya, Yongama, was it invited to the VBS board meeting?
Through you, Mr. Commissioner, we were not invited. We have been trying to get meetings with them, and they seemed to be busy at the time until they told us that they're going to have a board meeting, and we insisted that we must meet with them so that we will get to make a decision on what needs to be done about the fact that PIC was not given fair notice to participate in the rights issue.
At this time, were the two PIC representatives, Mr. Magula and Mr. Nesani, on the board?
Yes, through you, Mr. Commissioner, yes, they were part of the board.
So although they were board members, and they would have then been aware that the PIC had not been informed as board members, because they should have been aware of what the rights issues were and what was happening. Is that correct?
They would have been involved through you, Mr. Commissioner. They would have been, or they would have known about that instance.
Okay, let's proceed. Paragraph 28.
Okay. Subsequent to numerous discussions and email correspondence, it was then agreed that VBS will give the PIC an extension to exercise both rights issues in respect of the initial notice and the extended notice at the same time. This resulted in the PIC approving via round robin to participate in the second, which was the initial, and the third extended rights issue at 90 million rand, and the original shareholding of the PIC at VBS was restored to 25.26%. I have attached correspondence between the PIC, represented by myself, and Mr. Truter on this matter for ease of reference, marked as Annex B.
Once again, when referring to Annex B, that's a series of communication, emails, and documents exchanged between yourself and the VBS CFO, Mr. Truter. Is that correct?
Through you, Mr. Commissioner, yes, that is correct.
Thank you. Let's proceed. Paragraph 31.
Okay. Vele Investments Pty Ltd, shareholding in VBS. In the course of finalizing the report to be approved by PIC on the participation in the rights issue discussed in paragraphs 25 to 30 above, it came to the attention of the team that there was a new shareholder, namely Vele Investment, which was initially not known, that had suddenly held 53.20% shares in VBS. Ms. Lufuno, Nechikweta, Ms. Kintiende, and I inquired from VBS about this shareholder, and we inquired or asked questions through Mr. Philip Truter, who was the then CFO.
And this shareholding was, or by Vele, was prior to the rights issues?
That was prior to us exercising our rights issue.
Prior to you, but the rights issues that they may have
Yes,
done
that
it
they
from
may
the
have.
previous
That is
rights
correct.
issue that you were not included in.
That is correct. Okay. Mr. Truter informed us that this shareholder was part of the other shareholders, which is the other in, because there's a shareholding which is, I think it's various organizations and individuals which held about 49% of VBS. So when we inquired, he told us that this shareholder was part of those other, and the various that participated in the second rights issue, when the major shareholders, which were the PIC and Tiambeu Investment, did not participate. My understanding of the rights issue is that it is an issue of shares offered at a special or discounted price by a company to existing shareholders in proportion to their current shareholding of shares. Hence the reason that the team had to understand the strange appearance of the new shareholder.
Now, just going back to the strange new shareholder, Vele, it's public record that it was one of the biggest recipients of the so-called ill-gotten gains from VBS. Is that correct? Vele Investments was one of the biggest recipients of ill-gotten gains from VBS in the...
I think according to the Great Bank Heist report by Advocate Terim Tau, that's where that information is coming out.
And do we have more information on exactly who Vele Investments is? And the...
We can also make that information available to the Commission, Mr. Commissioner.
Do you have it readily to hand or not?
Sorry?
No?
Sorry, pardon me.
Is, or who exactly Vele Investments are, who the people involved in, do you have that information easily to hand? Or is it something that you would need time to provide to the Commission?
It is available, it is information that we have available, Mr. Commissioner, through you, and we can make it available to the Commission.
I'm asking, though, if it's to hand, because you could read it into the record now. If it's not to hand and you need to give it to us later, that's fine.
We'll do so.
I'm sure we'd have it in the report, but I'll look for it and get it.
Mr. Commissioner, that concludes Ms. Mdluli's evidence. Our next witness is ready to testify.
Just a few questions.
Given the events that you indicate occurred relating to the rights issues and your concerns around what was happening, Was there discussion between yourselves as the PIC and the two board members who were there at the behest of the PIC about what was actually going on, what was happening at VBS?
Through you, Mr. Commissioner, the VBS representatives, they would usually tell us that they are board members. They are not PIC representatives in terms of like a shareholder representative when it comes to board matters. So those roles should be separated.
I accept that because they obviously have a fiduciary duty to the board that they serve on. But at the same time, there may well be a question that says, look, you're not happy, whether it's through the chair, through the CEO, this is what's going on, because you know, if your investment is diluted without you knowing, without the requisite checks and balances in place, there is a responsibility between the PIC and that entity, whether it's VBS or anybody else, to say what is happening here. Yeah. So, did any discussion take place in the manner other than what you've indicated here about following your rights or having the rights issue and being able to look at that? But the question for me is, why did that happen in the first place, and what would that have triggered an interaction from the PIC with VBS to say what is going on here and why?
The interaction with the client after or post-investment is usually between the client and our PMV or post-monitoring division. So they are the ones who should keep contact with the client, as well as the investment team who was involved in approving the transaction. So in this instance, that is why the team had to take initiative and make sure that this thing was done as was initially intended. Or it was supposed to.
And did you interact with the post-investment team as well to express concerns and ask them to look at things?
Through you, Commissioner, yes, we did. Hence, we had Mr. Kaya Zonke and Yongama Melapi of PMV during that meeting as well.
So is it correct to say that they also didn't have joy with VBS, the people in PMV who were responsible for monitoring the investment?
Through you, Mr. Commissioner, I think there'll be a better place to respond to that question. But every time when they had issues with receiving information, they would ask for assistance from the investment team, which was majorly myself, and then I would call Mr. Truta or send him emails and remind him that he has to submit documentation to our PMV division.
Thank you. It seems like the questions have run dry.
In terms of the changes that were put into the final agreement, you know, was that found out after the collapse of the bank, and there was something done about it?
Through you, Mr. Commissioner, I'm the one who got aware of it at that time, because the person who was responsible for the agreements or who was making sure that the agreements were signed is the legal representative, or the legal division was responsible for making sure that the agreements are signed.
Yes, once you found out what happened, was something done about it, or you just found out and kept quiet about it?
Through you, Mr. Commissioner, it was not only me that found out about it. I think it was something that was discussed at the PIC. PMV division also knew about it. And in this instance, I'm not sure of the processes that was followed to resolve or attend to that issue. I cannot talk to it because I don't know.
Just to place it on record, Mr. Commissioner, we intend to call a person from the legal division to speak to the whole question of these inserted clauses into the agreement.
Yes, thank you. Ms. Mluli, thank you very much. Thanks for your time. And thank you for making yourself available to come and testify before the Commission. It has helped us a lot. Thank you.
Thank you, Mr. Commissioner.
Your full names are?
Sello Simon Ngwane.
Do you have any objection to taking the oath, Mr. Ngwane?
No, Commissioner.
Do you swear the evidence you're about to give will be the truth, the whole truth, nothing but the truth? Raise your right hand and say, "So help me God."
So help me God.
Thank you very much. You may be seated.
Mr. Kwani, you've also prepared a statement in relation to the evidence you're about to give to the Commission, is that correct?
Yes, Commissioner.
And you were not compelled to prepare the statement or to give the statement?
No.
Nor were you compelled to insert things in your statement with which you didn't agree?
No, Commissioner.
Thank you. Let's start from paragraph 1.1 of your statement.
Thank you, Commissioner. I, Sello Simon Ngwane, a South African national, confirm that I reside at Pretoria, South Africa, and further confirm that the contents contained in this statement are true and accurate. I was employed by the Public Investment Corporations on the 2nd January 2011 and have been in its employ since then with uninterrupted service, holding the position of Operations and Investment Support Manager, which position I hold even today, reporting directly to the Executive Head Investment Management. I have been requested by the Judicial Commission of Inquiry into allegations of impropriety regarding the PIC Judicial Commission of Inquiry investigators to submit a statement which details the role and responsibilities of investment management operations, IM operations, with regard to the procurement process as it relates to the due diligence process within the listed investment, and also in relation to the role of IM operations with regard to the disbursement of the 350 million revolving credit facility approved for VBS Mutual Bank, which I'll refer to as VBS. The following section deals with the role of the investment management operations and the role of investment management operations with regard to the VBS. Investment Management Operations Division. The division falls within the Investment Management Division, or the unit falls within the division called Investment Management Division of the PIC, with its core role being to provide efficient and effective operational investment support to the investment process and teams. The Investment Management Operation is led by myself and has a staff complement of 6 comprising of the following positions. 2 fund administrators occupied by a gentleman called Gabriel Ngale and Tsepiso Nja. Murufe Masemula, a divisional administrator, and additional 3 divisional administrators referred with the names Francina Midupi, Mpone Molai, and Khosi Tselapedi as a website administrator. The key responsibilities of investment operations includes, among other things, assisting in implementing appropriate IT systems to support the investment process, assist also to develop and implement appropriate processes, policies and frameworks to ensure seamless execution of unlisted investment activities. The IM operation plays a role across various aspects of the investment process, including but not limited to funding application process, due diligence through leading the appointment of service providers to conduct due diligence or any other assignment, handover process, disbursement process, whether initial or subsequent disbursement. On the corporate side, the IM operations coordinate and assist and liaise with internal and external auditors in regard to internal and external audit work within the investment divisions. the IM operation contributes and provides inputs to various monthly and quarterly reports prepared by various divisions within the PIC. Below is a key investment and other processes where IM operations is involved: unlisted investment procurement, unlisted investment disbursement process, domestic and international travel process, and management fees. I'll move to paragraph 4, which deals with the unlisted investment procurement.
Before moving on, Mr. Nkwan, can you just explain these roles that IM operations plays? Unlisted investment procurement, what does that entail?
Through you, Commissioner. So once a transaction is approved to go to DD by PMC1, then the investment team will then assess whether the due diligence would be executed by either internal capacity, using internal capacity, or appointing external advisors. So how we assist in that process is that the process of appointing the external consultant, we lead that process, we coordinate that process. That would include working together with the deal team to put together the scope for the DD. And also, once the scope is finalized, we will also run with the process of issuing the request for proposal to the various service providers, which would source from the approved database. And obviously, from submission of the proposals from the respective service providers, we'll then coordinate the process of evaluation of the proposals from the service providers, which the deal team would then focus on the technical side of it. If, for example, it's a technical DD, they will then assess or evaluate the proposal from a technical point of view, and then from our side, we'll then look at the other side of it, which is mainly administrative part of it, including the evaluation in terms of price and of course, BEE. And then we'll then run with the process of the recommended service providers for appointment or approval to appoint by the delegated official. And in terms of the disbursement process, our role is that all the initial disbursements, following the handover meeting, we will run with the process of putting together the disbursement file. And in my statement, I've actually articulated exactly what is contained in that disbursement file, which I will cover the rest of our role as I go through my statement. The investment mandate concluded between the PIC and its client makes provision for PIC to appoint third-party advisors, and costs associated with such appointment of third parties shall be for the account of the client. The client in this case I'm referring to, in our case for unlisted investment, I'm referring to the GPF, UIF, and NCC. Amongst other things, the advisors can be appointed to conduct due diligence on the transaction on behalf of the PIC, particularly where the PIC does not have the necessary internal capacity to perform such due diligence. The appointment of such third parties follows and is governed by an approved assets under management procurement policy. It must be noted that the specific divisions within this apologies, Commissioner. It must be noted that specific divisions which this policy is applicable to, is the private equity and SIPs, and the impact investing and funds of funds, and any other division that appoints service providers where costs are incurred on behalf of the clients. The unlisted properties division has its own procurement policy and process, and accordingly not dealt with in the statement. It must be emphasized that when the PIC procures on behalf of its client, who neither are governed by the PFMA nor are organs of state, or may be subject to regulatory exemptions or exclusions, or whose investment activities are excluded or exempted, it is important to note that the provisions imposed by such government procurement legislation are not applicable to such clients. Notwithstanding such exemptions, the Unlisted Investment Division endeavors to ensure that this policy espouses the principle embedded in the government procurement legislation, such as fairness, equity, transparency, competitiveness, value for money, and risk management. The process outlined below must be read with with the Unlisted Investment Delegation of Authority, the AUM procurement policy, and the procedure manual for the unlisted investments. The PIC Supply Chain Management Unit are required to confirm for any AUM procurement undertaken on behalf of the PIC clients that the approved process have been complied with. Procurement process. Once the Portfolio Management Committee Unlisted Investment, which is PMC1, has approved for a transaction to go to DD, the investment team, environmental, social, and governance team, which is referred to as ESG, legal team, and the risk team must decide which component of the due diligence will be outsourced and which component will be executed using internal resources. In case where the decision is to outsource, this process is led and coordinated by investment management operations team, except in case of legal due diligence, which is coordinated and led by the legal unit directly. It must be noted that the same policy referred to above is applicable to the procurement activities by the legal unit. This arrangement I found at the PIC when I joined. As with other AUM procurement, IM operations was and is responsible to monitor compliance with the provisions of the AUM policy and processes, and further coordinate and oversee the procurement process. I was not sure of the rationale of this separate arrangement and don't recall what explanation was provided when I raised this matter, but was comforted by the fact that the PIC Supply Chain Management Unit signed off to confirm that all due processes have been complied with all legal unit recommendation to appoint legal firms for due diligence or drafting of legal agreements. The respective teams assisted by the IM operations team will prepare requests for proposal, RFP, and such RFP will include, amongst other things, at a minimum, background of the transaction, the scope of the due diligence, evaluation criteria, timelines for submission of proposals, and other administrative requirements. Service providers with appropriate and relevant experience will be selected from the approved database. The database was established some 3 years ago and is managed and maintained by the IM operations. In terms of the AUM procurement policy, potential service providers can apply to be listed in the database at any given time by completing an application form. Once the application form is completed and the required documents attached, such will be submitted to IM operations. An administrator within the IM operations will prepare a memo for submission to myself, and after review, recommend to the Executive Head Investment Management, Ms. Rubina Solomon, who will approve the service provider for listing. Once the submission is approved, the service provider will be listed in the database. If there are no sufficient and/or experienced service providers on the approved database, a request for approval to approach service providers outside the database will be prepared, and such request will be approved in line with the delegation of authority. Once the RFP is completed and the required number of service providers have been identified, whether through the approved database or outside the database, the RFP will be issued by the IM operations team to the selected service providers. The RFP will be accompanied by the declaration of interest and non-disclosure agreement to be completed by the service providers approached. Depending on the requirements of the RFP, the potential service providers will submit proposals in electronic form and/or hard copies to IM operations team within the required timelines as stated in the RFP. Once received, the IM operations team will convene an evaluation task team, and the proposal will be evaluated in line with the AUM procurement policy and the RFP criteria, as outlined in line with the RFP criteria. All members of the task team are required to complete declaration of interest forms before they can participate in the evaluation process. Following the evaluation process, the service provider with the high score will be recommended for appointment. The memorandum recommending the service provider with the high score will be prepared by IM operations. The memo must be accompanied by relevant document to support the recommendation. The approval of the recommended service will be done in line with the delegation of authority. Once the approval is obtained, the IM operation shall notify the successful service provider formally, and also unsuccessful service providers will be notified. The IM operation shall lead and coordinate the drafting and/or review of the engagement letter between the PIC and the successful service provider. The engagement letter must also be reviewed by legal and signed in line with the delegation of authority. Once an engagement letter is signed, a kick-off meeting, which is led by the investment team, is scheduled by the operations team with the appointed service provider for a briefing on the proposed transaction and the scope of the DD. Once the appointed service provider has completed the scope of work, as outlined in the RFP, the service provider will prepare a due diligence report for submission to the investment team. The team will engage with the service provider until the final report is submitted. Depending on the terms of the engagement letter, the service provider, when submitting the final report, meaning the DD report, will include the invoice for the work done for payment purposes. The IM operations will facilitate the approval of the invoice for payment purposes and submit accordingly the approved invoice to finance for payment. And once paid, finance will then submit a copy of the proof of payment to IM operations team.
We move now on to the disbursement process.
Question? Yeah, question. Looking at this procurement process, especially 4.9, I wonder, in general, when you put people on a database, just, a few questions there is that how do you put them, first thing? Second point is how do you choose among them generally, and especially if someone has done work for the PIC for a while, do you drop them and choose the others, How does this whole database process work? And if people are not on that database, you say it was done about 3 years ago, how do they get onto that database? So those broad general questions on how that database works.
Thank you, Commissioner. So, as I've said, Commissioner, that the database was established some 3 years ago. And as part of the policy, the procurement policy, there's a provision in the policy which allows service providers who want to list on the database to apply for listing on the database. The process of listing is that there's a form that they are required to complete. That form has a number of things in it. For example, we require that you provide us with the type of services that you provide, the directors of the company, the shareholders of the company. So there's a number of things that we require from a service provider who wants to be listed on the database. Now, in terms of the policy, any person who wants to list on the database can walk in and request an application form to complete in order to be listed on the service on the database. Further, Commissioner, through you, in terms of our policy, we've got a rotation guideline. So, and the reason why we have this rotation guidelines is to make sure that we don't have one service provider being appointed often, because you do have, that's one of the risks that we're facing, to say, the one service provider can be appointed on a number of transactions. Immediately, that would then deny other service providers who are listed on a database being appointed. Hence, we have then developed that guideline in the policy in terms of rotation, so that we can give other service providers within who are listed on a database the opportunity to be also appointed to do work for PIC.
Sorry, just on that point, a question I would ask is it obligatory to follow that process? Because does it not disadvantage people who actually do perform well? So that if you've got a service provider who actually does everything that's expected, gears up to be able to ensure they deliver exactly what is required, but then you drop them because of rotation, and you might get somebody who does not perform as well, but they're filling your rotation requirement, not your skill, competence, expertise requirement. I would hope that it's not a mechanical rotation, but looking for opportunities. Certainly there should be opportunities for a range of service providers to participate. But I would be a bit concerned if it was okay, you've done brilliantly, you're our best service provider, but your rotation time has come up, off you go, and we put in somebody who can't do the job, or even who can do the job. But you actually then have a situation where service providers have to grow and reduce and grow and reduce, and therefore you actually destroy the capacity over time. So I'm just really asking, not that one doesn't need to find ways in which you create greater opportunity, but whether it's simply a mechanical question, you've done your turn, now it's somebody else's. Thank you.
Thank you, Commissioner. The rotation, Commissioner, it's not to it's not intended to disadvantage those service providers who are performing. One of the things that we do is that for every due diligence, if we appoint a service provider to do a due diligence on a particular transaction, once the work is completed, one of the things that we do, as operations, we engage with the investment team. Because post the appointment, the service provider will be working with the investment team, just to assess the performance of that service provider. And where, for example, the view of the deal team is that that particular service provider has done a bad job, we don't stop there. What we also do is that we convene a meeting with the service provider, because sometimes if we don't do that, you're only hearing one side of the story. And for whatever reason, they could be saying that the service provider is not performing. But what we do is that we further engage with the service providers, just to also put the facts on the table based on what the deal team is saying, so that we can also hear the side of the service provider as to what so that we give both parties a chance, so that both parties can put their views on the table. And from that discussion, through you, Commissioner, we would then obviously come up with a plan in terms of how then do we assist the service provider if it's something that we are able to do in terms of that service provider being able to perform going forward. But we do give opportunity to these service providers to say the side of the story, so that we have both sides of the story, to make sure that a service provider is not blacklisted because somebody is saying he's not performing. In terms of the rotation, as I've said through you, Commissioner, it's not intended to disadvantage those service providers that are performing. But those who are not performing, they are flagged on our database, and they are flagged for example, we'll put them on hold if it's something that is continuous, the non-performance is continuous, or there's no improvements that we see from the service provider.
Is it mechanically applied, or is there space and leverage to reappoint and so on?
Yes, there is that space to reappoint.
Yeah, I think you were still trying to continue, so I think continue, because I'm interested in following up the points. Yeah, on this issue.
On the issue of
database.
Oh yeah, okay.
Like how it works.
Yeah. So as I've said, the database, anyone can walk in and apply to be listed on the database. And obviously, as I've said, that there's a form that's completed which requires a number of things. And once we're happy that the service provider meets the requirements, that service provider will go through the internal process for appointment.
Then a question, so if you got on transactions, let's say you got, what, sort of 50, 60 legal firms. I mean, there are many legal firms in the country, in Joburg in particular. Or you got advisors, transaction, advisors, there are many also, from big ones to boutiques. Can it happen that you are on database for 3 or 5 years without being called to do some work?
I don't think it's possible, because one of the things that we do is that when we select service providers, part of the process of trying to rotate is that when we select service providers, because our database is structured in a way that you are able to say, this service provider provides, for example, services on technical DD or financial DD. So if, for example, the RFPs for a financial DD, right? So we will then select from the database all the service providers that provides, for example, financial DD. Part of our policy is that the minimum requirements in terms of how many people you can approach, it's a minimum of 7 service providers. So you can't select below 7, because unless, of course, in the database we've got only, let's say, 6 service providers that provides, for example, a technical, or technical DD on mining. But when you select service providers from the database, you gotta make sure that you select, first of all the service providers that provides financial DD, which in this case there will be quite a lot of them that does service DD, financial DD. Now, as part of the whole process of selecting this, we'll say, and as part of trying to rotate, is that we will then obviously make sure that service providers that were not approached in the previous transactions, for example, they're included in that list of service providers that we will approach. In some cases, you find that we approach 15 service providers just to perform a financial DD on a transaction, just to make sure that people are given opportunities to make sure that they submit proposal to the PIC. We had in previous instances where we had service provider calling and saying, I've been listed on a PIC database and I've never been approached. And part of making sure that you don't have those kind of instances is that we make sure that in terms of the service provider that we approach, we make sure that it's a big number. It's not 3 or 4 people, 4 service providers, and those who were not approached in the previous transactions are included in the RFPs going forward.
And they can complain if they are not happy.
They can complain.
They can complain.
Yes, they can complain.
Okay. Then the one question I wanted to ask you is, and I think it has come up here, but it will probably be dealt with in the future. Do you have advisors that are sort of, one person said they got a high hit rate with the PIC, people who advise the PIC on transactions, say evaluations or whatever, that have got a so-called high hit rate? And how does that come about? Do you know about it, or is it part of your work?
Through you, Commissioner, I take it when you say high hit rate, you mean they often quite get work from PIC. That's, if I understand you, through you, Commissioner. I mean, we have instances where the deal team, for example, will prefer audit firms. You find instances where they prefer audit firms for financial DD. But of course, just to make sure that everyone gets an equal opportunity. If, for example, in this case, for example, if ENY was appointed to do work on a particular transaction, as part of this process of making sure that everyone is given an equal opportunity, we are not going to include ENY in the RFPs going forward. But yes, we do have, or previously we did have, advisors where it's like, you see this person working on this transaction, tomorrow, PMC approve another transaction, you see the same person. But as part of making sure, in the last 2-3 years, just to make sure that everyone is given equal opportunity, and also hence we had to put together this policy to make sure that everyone is given fair opportunity to pitch for anywhere from PIC. But I admit there are instances previously where you see the same person doing work for PIC.
And roughly, how big is that database? How many companies? On transactions, I think. I don't want to talk about supply chain, just on the transaction side.
Well, on the transaction, the database, I stand to be correct, but I think there are more than 50 service providers.
Okay, so it's not like hundreds and
no, it's not like hundreds and hundreds of service providers, but I think there are more than 50 service providers. Yeah.
Yes, across the board. So it's sort of value for valuations, for legal advice, for what?
So maybe I should just correct through you, Commissioner. The the 50 is excluding legal firms. The legal unit has got its own database of law firms. Sorry, as I've said in my statement that the procurement process as it relates to legal firms is not handled by, is not coordinated by investment management operations, but by the legal unit themselves. So, yeah, the 50 is just excluding the legal. Yeah.
So it will be the normal ones like Deloitte,
Yeah.
Ernst & Young,
Yeah.
boutique firms, the standard banks and all that, yeah?
Well,
Correct? No?
majority of them are black-owned firms, small firms. Yes, you do have Deloitte, you know, and audit firms, yeah.
All right, thank you, thanks.
We can proceed from paragraph 5.1 under unlisted investment disbursement process.
Yes. The disbursement process covers initial and subsequent disbursements. The process followed for initial and subsequent disbursements are substantially the same, except on specific areas which are outlined below. It must be noted that the processes outlined below represents the current process, disbursement process. Both processes would commence post-conclusion of the legal agreements and the investment handover process. I just want to pause through you, Commissioner, on the investment handover process. Once the legal agreements are concluded, as part of our responsibility is to call what we call a handover meeting. In that handover meeting, we would invite the deal team, who are the owners of the transaction. We would invite all the internal stakeholders, for example, including legal, including ESG, including PMV. Now, the purpose of this, and my colleagues have spoken about it in the previous submissions, the purpose of this meeting is to appraise, to bring everyone on board in terms of the transaction. For example, if you remember in the investment process of that Mr. Roy Rashta articulated at the beginning of the commission, finance, for example, is part of the whole invest, because ultimately, and they come post mainly after the transaction is approved. So therefore, we call this meeting so that everyone can have the same understanding of the transaction prior to any disbursement that would happen on these transactions. And further to that, our requirement of the handover meeting is that the deal team prepare presentation, because obviously in that handover meeting you will have legal agreements and appraisal documents, and there's quite a number of documents. But just to make sure that everyone is on board, the requirement is that the deal team must put together a 2-3 slides to give background of the transaction. And that's the reason why we have it, so that everyone is on board as we now move to the disbursement process for a particular transaction.
Paragraph 5.4.
This process outlined below must be read with the unlisted investment delegation of authority, the procedure manual for unlisted investment, ESG, legal unit, risk unit, and portfolio management and valuation and finance procedure manuals. Initial disbursement process. Once the handover process is complete, the transaction will move to the disbursement process. The investment team and the IM operations team will together prepare a disbursement file. The disbursement file will be prepared in line with the disbursement checklist 1, which shall be signed off in line with the delegation of authority. The template of the disbursement checklist is attached as Annexure E1.
Just before we move on, Annexure E1 is the second final document in the annexures. Is that correct?
It's in terms of my annexure, my documents is just a document before Annexure F.
Yes, that's correct. Apologies, Mr. Commissioner, we hadn't put a tab, but it is that document before the extract of the internal audit report.
Is it the one headed Isibaya, VBS loan, or what is it?
Facilities. Yes,
That-
Commissioner.
Yeah.
Yes. Thank you.
Can I continue? The purpose of the disbursement checklist 1 is to outline all documents that must be included in the disbursement file, which may include but not limited to the following: copies of the approving committee submissions, resolution of the approving committee, copies of the legal agreements, FICA certificate compliance document, completed declaration of interest forms. This declaration of interest form is completed by the deal team. CP satisfaction letter. Accompanying the disbursement file will be a disbursement memo requesting approval to disburse funds. This disbursement memo and the checklist 2 will be signed in line with the delegation of authority. Critical in the disbursement memo is the confirmation by the respective heads of the following. So meaning that the memo will be signed by the following executive heads. For example, in a case where for example, Roy's or impact investing transaction, Roy will then be the executive head signing off. The confirmation, so I'm on 5.8A. In respect of the executive head, the investment falls under. Such executive will confirm the following: that all approval conditions related to the investment and the drawdown conditions for the request have been met, and the client is entitled to draw from the available funds and accordingly recommend payment. In respect of the executive head risk, confirmation that all risks, excluding legal risks, identified at the approval stage are the same and no new risks have emerged as at the date of this drawdown request, and accordingly recommend payment. In respect of the executive head legal, confirmation that all legal risks identified at the approval stage are the same and no new legal risks have emerged as at the date of this drawdown request, and accordingly recommend payment. In respect of the executive head ESG, confirmation that all ESG risks identified at the approval stage are the same and no new ESG risks have emerged as at the date of this drawdown request, and accordingly recommend payment. Now, through you, Commissioner, these confirmations were introduced in March, and I'll talk to it when I come to section 6 of my statement. Were introduced in March 2016, and the reason why is that prior to this, the disbursement memo will just have, for example, under the executive heads, will just says recommend, not recommend. But the question was always that what are you recommending? What are you signing off when you sign off the disbursement memo? So what we then did, we then went through a process where we then looked at each and every executive heads to say, if you're signing the memo, what are you signing for? So that tomorrow there's no confusion as to why have you signed the memo, because then the memo was just saying recommended, and no one was actually able to articulate to exactly what are you recommending, and hence the introduction of this of these confirmations. Further confirmations will be provided by senior managers within the areas referred to above through disbursement checklist 2. The critical in the disbursement checklist is the following confirmation by the respective senior managers reporting to the above executive heads. In respect of IM operations reporting to the executive head investment management, confirmation that 1, the signature on the drawdown utilization request matches the signature on the PIC records. 2, there is sufficient funds available from the committed funds to honor the request. 3, the bank account details included in the drawdown or utilization request matches the bank details or bank account details in the PIC records. In respect of portfolio management and valuation, reporting to the executive head investment management, Confirmation that the conditions relating to the current drawdown or utilization have been met and the client is entitled to the draw from the available funds. Furthermore, that there are no conditions that have emerged as at the date of the utilization or drawdown or utilization that would require PIC not to honor the current drawdown or utilization as stipulated in the legal agreements. In respect of the investment team, reporting to the executive head, either impact investing or private equity or funds, confirmation that the conditions relating to the current drawdown/utilization request have been met and the client is entitled to draw from the available funds. Furthermore, that there are no risks or conditions that have emerged as at the date of the drawdown/utilization that would require PIC not to honor the current drawdown or utilization as stipulated in the legal agreements. In respect of legal advisor, reporting to the executive head legal, confirmation that all legal risks identified at the approval stage are the same and no new legal risks have emerged as at the date of the utilization or drawdown, including that there is no non-compliance with the prevailing legal agreements, which would require PIC not to honor the current drawdown or utilization. The above confirmations are intended to provide the approver with assurance that all conditions have been met before funds are released, and there are no new unmitigated risks which the investment will be exposed to. Once approved, the disbursement memo and the disbursement file will be submitted to the investment finance for payment of the funds in line with the memo. Once payment is made, investment finance will forward proof of payment to IM operations team for filing in the disbursement file. Once disbursed, the transaction will move to post-investment monitoring and evaluation. Subsequent disbursement process. The IM operation team is responsible to initiate subsequent disbursements once they receive a drawdown or utilization request from the existing investee companies. These requests are mainly received from investee companies through emails. Once the IM operations team receives the drawdown request, a disbursement memo, the disbursement checklist 2 will be prepared by the IM operations and signed in line with the delegation of authority. The disbursement memo will be accompanied by the following documents: disbursement checklist 2, capital call or drawdown notice, portfolio company update, banking details confirmations, summary of the capital drawn to date, and any other any other document relevant to the call. The disbursement memo and the checklist will have the same confirmation as in case of initial disbursement by the executive heads and the senior managers, and both will be signed in line with the delegation of authority. Once approved, the memo and the related supporting document will be submitted to investment finance for payment of funds in line with the memo. Once payment is made, investment finance will forward proof of payment to IM operations team for filing. IM operations role in VBS Mutual Bank. As outlined above, the investment team and IM...
Just a question. So in terms of your process, do you also service the listed side, or is just the unlisted side?
Through Commissioner, it's only the unlisted side.
The unlisted?
Unlisted side.
The unlisted side.
We don't service the listed side.
They have a separate team, or is it within the IM, or is completely separate?
They have a separate team. So the IM operations I'm referring to is only for unlisted side within that investment management division I referred to at the beginning. Okay, so within that there is a separate team, but which is a listed team? No, through you, yeah. Commissioner. So the IM operations that I'm referring to here, it's only for unlisted. I assume that the listed side have got their own operations team that does their operations. Yeah. So we don't handle the.
You are assuming you don't know.
They have their own operations.
Oh, okay, all right. Okay, thanks.
So is it a question of the Chinese wall?
Yes. As outlined above, the investment team and IM operations team will prepare the disbursement file in case of initial disbursement and also prepare subsequent disbursement. The disbursement file will be prepared in line with the checklist, disbursement checklist, which shall be signed off in line with the delegation. In respect of the role of IM operations, the unit led the preparation of the disbursement following the conclusion of the legal agreement in case of VBS. The first disbursement amount of 100 million was paid to VBS on the 31st of July 2015. The disbursement memo, both initial and subsequent, of all the drawdowns have been prepared by the fund administrator or investment analyst and recommended by myself prior to such memo being circulated to the rest of the signatories in line with the delegation of authority. Paragraph 16.3 just gives a table in terms of all the drawdowns that were made on VBS following the conclusion of the legal agreement regarding the revolving credit facility of 350 million.
Are there points of emphasis that you just want to point out in relation to that table?
I wanted just to, because this is a revolving credit facility, and in terms of the agreement, what it means is that any capital repayment repaid by VBS would become available for redraw. Now, if we look at that column called, which is column number 4, if you count from the left, or from my side it's from the left, which says is drawdown, the commissioner will note that there's an amount of 82.9 million, 82,999,559, an amount of 54,443,227, an amount of 21,709,792. These are the amounts that have been repaid at the days as outlined in the second column. For example, the 82,999,559 would have been a total capital repaid by the 8th of March 2017. And therefore, if we go to the next line under capital call number 6, on the 9th of March 2017, VBS drew 80 million from that 82,999,559, which was repaid as of the 8th of March 2017.
Is it fair to say from this table that immediately after payments, VBS would would make drawdowns, or shortly after making capital repayments?
Well, if you take, for example, the 82.9 million, that is repayment over a period of time. So what we are saying that as of the 8th of March 2017, the sum of the capital repaid by VBS amounted to 82.9, and hence, therefore, that 82.9 was available for redraw on the 9th of March 2017.
All right, thank you.
Can I continue? Based on the nature of the facility, which
let's double check. So the 82 million, are you saying it's a breakdown of something else? This isn't a lump sum.
Yeah, it's a sum of all the capital
Some
repaid,
payments
yeah,
which have happened before.
up to the 8th of March 2017.
Yes, yes.
And therefore, you'll see then the capital call number 6, or which was processed on the 9th of March 2017 for 80 million was actually from that capital repaid of 82.9 as of then, because it's a revolving credit facility.
Did you follow up with the bank, how they were using the money? Because it was ring-fenced and it was supposed to be used for that contract financing. Were they doing that?
So our role as it relates to this disbursement is that any disbursement, obviously, in the legal agreements, there would be conditions to any disbursement. In this case of VBS, when they drew any amount that is reflected in the table, there are a number of documents that they're supposed to provide before we can process for example, the underlying agreements in terms of the fuel supply would be part of the submissions from VBS. So we would not obviously proceed without these documents or those conditions as it relates to any disbursement that we make without us receiving those documents, having gone through them, making sure that those are correct documents that we, as it relates to whether, once it is disbursed, whether they're actually going to use it, we don't go to that extent. Where we are, we expect that, for example, the PMV team, because they do post monitoring, post disbursement monitoring, they will then make sure that, or they will, as part of their normal monitoring, just follow up on the disbursements that we have made. Based on the nature of the facility, which is revolving, the repaid capital becomes available for redraw, which, as at the time of the statement, VBS has drawn down 134 of the withdrawal capital of 159. Revolving credit facility review and suspension of the drawdowns.
Just before you move forward, so there's an amount total drawdown. You say the last amount total is 324 million. What's that? Is
so,
that,
just to the total drawdown, right, is the 350 million, the original facility. And further to that, they've drawn 134, right?
Yes.
From a total of 159 withdrawable amount, which is sitting in that column, the fourth column. So all in all, they would have drawn 484 million. If you take the original 350 million,
yes,
plus the 134 million that they have drawn from the repaid capital of 159.
Yes, yes. Yeah. Okay, so this RCF was growing. It wasn't limited to that 350 million.
Yeah, it wasn't limited to the, because remember, in terms of this facilities, that any capital that is repaid,
yes,
it becomes withdrawable. So, but you'll always make sure that you gotta get back to the 350. As my colleagues have explained. But in terms of the total amount that has been drawn, if you take into account what has been repaid and which was available for withdrawal, then you're looking at the total of 484.
Okay. Okay, so when the bank went down, what was the total amount that they owed to the PIC on this one, on the RCF?
Okay, so and I will then just talk to the capital, without including any interest, because remember they had drawn 350, right, and then they have repaid that 159, and then they withdrew from that 159 134. In essence, for me, you would then have to take the 350. And then you have to say, of that 350, they've repaid 159. And then, however, they've drawn 134 from that. So you will then take the 350, which I think will come back to the 324 that we say. 324, yeah.
Which was the total amount owed at a certain point in time.
If we look at the principal amount.
Yeah.
Yes.
This is what they went down owing the PIC.
Just on that facility.
Yeah. Okay. Okay, all right. Okay.
Sorry, why do you say just in that facility? Was there another one?
No, I was just making the point that it's on this, on the facility, because the other one were just equity. Yeah.
It was the equity. And was there any security packages, arrangements on that one?
On that
324, if you're correct about that.
So my understanding of this that because the amount of standing was secured by the underlying fuel contracts, and I think we had session on the bank accounts of so there was underlying security on the 350, which were the fuel contracts.
Okay, so it could be that the PMV has managed to get something back, maybe?
I wouldn't want to comment on that.
Yeah. Okay, but I'm sure
I think there'll be best place to.
We will know about it at some point. I'm sure.
We will provide that information, Mr. Commissioner. As we know, that the bank is in liquidation, and I think in that application, it appeared that these contracts were fabricated. So we would have, but we will get that information and place it before the Commission.
You mean the fuel contracts were fabricated?
That is correct.
Can I continue? In line with the provision of the legal agreements, which I think was clause 18.1, and discussions amongst PIC officials, which included Mr. Paul Magula, former executive head risk, and Mr. Ernest Nisani, former executive head legal, counsel, governance and compliance, the PIC commissioned a review of the facility, 1 year into the facility. This led to the suspension of any further drawdowns. I have attached as Annexure A to this statement outlining the concurrence of the revolving credit facility review and the suspensions of the drawdowns, which I personally sent to the VBS CFO, Mr. Philip Truter. The review of the facility was led by PMV, or Portfolio Management Evaluation, assisted by the transaction team. The IM operations were not involved in the review and have never had sight of the outcome of the review. However, during the resumption of the disbursements, I am 100% sure that I would have consulted with the PMV team to confirm whether we can now resume the drawdowns, and there are no adverse findings from the review. The review was commissioned after VBS had fully drawn down on the 350 million, which I think it was about 9 months into the facility. I was not aware that part of the conditions of the investment committee approval of the 350 million was that the 200 million could be disbursed, and based on the performance, the balance of 150 million can be disbursed. This condition was also not contained in the facility agreement. Following the suspension...
Sorry, can I just ask a question on that? Because this has come up a number of times already, that there seems to be a difference in the evidence provided to us by a number of statements so far. There seems to be a difference between what is agreed and then what is captured in the disbursement or the credit facility or whatever the entity is. And I would think that perhaps there needs to be somewhere along the line some review by our team as to how often did this occur in the cases that we're looking at, where there's an investment committee decision with conditions or pre-conditions or conditions precedent that are not captured in the agreement, in the legal agreement or in the facility that's granted, that creates a problem down the line where there is a gap between what is expected, what is agreed, what is approved, and what is finally concluded. And I think it would just be useful to get some kind of sense of that frequency, because this is happening far too often in the information before us. And therefore it must raise a question about what the legal team is doing to see that see-through from the initial proposal and all the things that have been said are captured in the final document.
Thank you, Commissioner. We'll do so.
Can you continue? 6.7. Okay. Following the suspension of the drawdown, which communication was sent to VBS on the 5th of August 2016, the drawdown resumed in 2017 with a request to disburse 80 million from the withdrawable amount of 82.9 million. The confirmation of the withdrawable amount was received from the Unlisted Investment Valuation Unit within Finance, And in respect of the drawdown for 80 million, I have attached as Annexure B to the statement the email we have received from Mrs. Tembekile Maseko, an official within the Unlisted Investment Valuation Unit. Supporting the email is an amortization schedule which confirms the withdrawable amount of 82.9 million. This amortization schedule is attached as Annexure B1 to the statement.
So this Annexure B1, it's a spreadsheet, is that so?
Yeah. Yes, Commissioner.
Mr. Commissioner, I confirm that it was difficult to have it printed. It's a big document, but it has been provided in electronic form to the Commission.
The drawdown notice from 80 million was received from VBS on the 15th of March 2017. The request from the VBS is attached as Annexure C to this statement. The drawdown for the 80 million was processed on the 13th of April 2017. The drawdown was approved under the new process, which is outlined below. The drawdown was signed off in line with the delegation of authority. A new drawdown template. In March 2016, we implemented a new disbursement template and enhanced the drawdown memo. The enhancements were intended to provide the approver with the assurance that all conditions have been met before funds are released, and there are no new unmitigated risks which investment will be exposed to. We have attached as Annexure D to this statement the discussion that led to the enhancement. It must be noted that VBS Capital Call 1 to 4 was not processed under the new disbursement templates. As stated above, the 80 million disbursement was done under the new disbursement template. We have attached a copy of the disbursement memo and the supporting documents related to the 80 million as Annexure E to this statement. The IM operation assumed that there were no material adverse outcome from the RCF review, as all delegated people have signed off the disbursement. Also taking into account that during the resumption of the disbursement, I'm 100% sure that I would have consulted with PMV team to confirm whether we can now resume the drawdowns, and there are no adverse findings from the review. Should there have been an adverse outcome from the review, it would have been detected by PMV and the deal team, and the disbursement for the HA would have been put on hold.
Before we proceed, would Mr. Nesani and Mr. Magula have been involved in the process of approving this or the review of the transaction?
Through you, Commissioner, I assume you're referring to the disbursement memo.
Yes, okay. Sorry, the disbursement memo. Would they have been involved in that as assurance providers, the one being in legal and the other being in risk?
Through you, Commissioner, yes, there were signatories on the disbursement memo, both Mr. Magula and Mr. Nesani.
And how did this conflict with them being board members? Wherein we heard earlier, there couldn't be discussion with them because their fiduciary duty belonged to the board, the head of risk, the head of legal, and they're now approving the disbursement for the very board that they sit on, which they can't talk to you about.
Through Commissioner, it's a common practice within the PIC. In fact, it's not them only. There are PIC officials who are sitting on boards of investee companies, but over and above that, they would sign the disbursement, or they would sign the disbursement from those investee companies. However, in this case, or one could then raise the issue of conflict of interest. I am aware or personally on one of the transactions where one of the colleagues was sitting on a board, and in terms of the process from their side, from the investee company, when the capital call, when we received the capital call, right, it would have the signature of the same PIC official. And therefore, for my comfort, my request was that that PIC official not sign the disbursement memo, because I view that as particularly for the fact that he's even signing off the capital call from the investee company, so that we have somebody separate who's going to then sign the disbursement memo. But yes, it's a practice within PIC at this stage. There are a number of transactions that colleagues are sitting on boards, but they also sign the disbursement memo.
Have you raised that with any structures within the PIC as a conflict of interest and a practice that has real risk involved about governance? I mean, there is a contradiction between what Ms. Mdluli said earlier about not being able to talk to them, and yet they're signing off the very disbursement. And where the fiduciary duties lie and where the responsibilities lie. And I'm really just asking whether, given that you have been aware of it, was that formally raised as a point for discussion in the PIC by you or any of your colleagues, that this is a practice that needs to be reviewed?
Through you, Commissioner, I don't recall raising it formally, but I think I had discussion informally with colleagues internally. And I think the view was that there are other compensating controls, because, for example, that memo is signed by a number of people, and including for example, in case of you take VBS, for example, you have PMV signing off also on the memo, and you have also ESG, signing off on the memo. You've got risk signing on the memo. You've got legal signing on. So the view was that. Yeah,
so the question I'm raising is that I understand that you may not have raised it formally, but because other entities are co-signing does not legitimate the practice that is there. It is something, because if I see X's, just take an example, if I see that risk has signed off, okay, I'm going to rely on risk. But maybe if I'm the risk person serving on the board, can I rely on you to be saying A in this circumstance and B in that circumstance? It becomes a conflict. So the question that arises is, who do you rely on who has signed off if there is that conflict? So it's not sufficient to say that there are other people who sign off as well. You can have 21 sign-offs, but everyone relies on the one below or the one above.
Through you, Commissioner, I take the point, and I think it's something that it needs to be looked at seriously within our processes. Yeah. Revolving credit facility agreement. As stated in above, the condition of the IC approval that the 200 million be disbursed and based on the performance of the balance of 150 million can be disbursed was not included in the agreement or the RCF agreement. Furthermore,
sorry, just before you come to the second one, because I'd also ask you that one to explain what these two additional clauses were. But in that first statement that you're making under 611, is that not a material non-inclusion? And therefore, if legal has signed off on that, how has that occurred? Because that is material, it's not immaterial. It's a very significant requirement that has not been met, but legal has signed off on the document. Who or how does that occur?
Through you, Commissioner, I agree. I agree. It's a material. I fully agree with. I think through you, Commissioner, and I think it goes back to that point of relying on other signatories. I think if you look at, for example, in terms of the legal agreements, part of our documentation in the disbursement file is a CP satisfaction letter. We place heavy reliance on that CP satisfaction letter. If we receive that letter signed off by legal to say all the CPs have been met, so we place reliance on it or on that particular letter. And I think as it relates to this, for example, this condition of by the investment committee, And it is clearly stated in the resolution. You can clearly read it from the resolution. Why it did not end up in the legal agreement, yes, it also baffles me. But some 2 years ago, and it will take me to an extra F, some 2 years ago, there was an audit finding relating to that specific issue of CPs not ending up in the legal agreements as approved by the committee. And one of the recommendations by the internal audit was that the respective divisions, for example, ESG, for example, when the transaction is taken to a committee or to PMC2 for final approval, they do their independent submission. For example, also legal, they will do their own independent submission. Now, in their submission, you find that there's conditions that they would want the committee to approve on a particular transaction. Now, so what had happened was that so if the committee approves those conditions from ESG, the executive head or the executive head of ESG did not have sight to the legal agreements until it's signed. So, which then was raised by the internal auditors to say, their recommendation was that going forward, we need to have all the respective executive heads who are interested or have got interest in the transaction to also co-sign on the legal agreements, so that would then confirm that they've reviewed the legal agreements and they've made sure that those conditions that they have tabled at the committee, PMC or IC, which have been approved, they're actually incorporated into the legal agreements. But recently we had, that was the recommendation of the internal audit, and it's attached as an extra F of my submission, where they have outlined all the recommendation. And my reading of the comments from the executive is that they have adopted those recommendations from the internal audit, just to mitigate one of those risks of conditions being approved by the committee but not ending up in the legal agreements. Now, whether that recommendation was fully implemented within the PIC is another question. However, what I wanted to note is that recently we went to the investment committee we're dealing with the delegation of authority for unlisted investment, and part of the recommendation of our recommendation to IC was to say for example, in terms of the legal agreements, before the final approval of the legal, who's going to sign the legal agreements, all these executive heads that are impacted by this transaction should sign off to say they're happy with the legal agreements, so that tomorrow you don't end up with legal agreements which don't have these conditions that have been approved by but the view at the meeting was that that could typically prolong the process, if I may use the word. The view was that it is the responsibility of the legal team, because they are drafting these legal agreements, to make sure that whatever conditions that are approved by the committee, they end up they end up in the legal agreements. And through you, Commissioner, I think for me, part of the problem is that there are instances where clearly it's an issue of, and lack of a better word, of performance, of people not doing what they're supposed to be doing. And then tomorrow coming up with processes to try to address a problem that is not necessarily created by a process, but by purely those respective divisions or officials not doing what they're supposed to do, and making sure that where you have people are not doing what they're supposed to do, proper actions are taken. And also bearing in mind that ultimately it also hinges around, what's in the balance scorecards of those various divisions. And therefore, if you don't make sure that within the balance scorecard of those respective divisions, you don't, for example, rate them in terms of amount of transactions approved, because it's relevant to what they do. The balance scorecard should be clearly, dealing with exactly what the division is supposed to be doing, rather than doing. So for me, my view was always that I think part of the problem is that we, in terms of when we try, where we're supposed to deal with issues, where we're supposed to deal with performance, we turn around and just create more processes, and therefore, you know, the process become inefficient, but purely because we're not dealing with the actual issue.
Sorry, can you just give us the date of the internal audit report, because it doesn't seem to have it?
The date of the internal audit report is dated April 2018.
Thanks. If we can go back to 611. I just wanted to understand what the 2 additional clauses were.
Can I continue?
Sorry, Commissioner, is your...
611, it says, furthermore, there were 2 additional clauses which were added to the RCF, which I did not understand.
Okay. Through you, Commissioner, these 2 clauses relate to the 3.5 and 3.6, relating to which my colleagues have here.
Can I just ask, after legal has done the contract, or drawn the contract, it doesn't go back to the level where conditions were placed. For instance, IC. The contract doesn't go to them to make sure that all those conditions are included.
No, it doesn't, Commissioner. Can I continue? As stated above, the condition of the IC approval that the 200 million be disbursed, and based on the performance, the balance of 150 can be disbursed, was not included in the RCF. Furthermore, there were 2 additional clauses which were added in the RCF, which I did not understand, which I found later after Vibes went into curatorship from one of the PIC officials.
Just to interrupt you there, do you think it was by omission, negligence, or was it intentional to have inserted those clauses? Or do you know?
I wouldn't want to comment. I wouldn't want to comment. I don't know the reason why. Why would we insert those clauses? Particularly the fact that this typically has to be part of the approval of, approval conditions. So I wouldn't want to comment because I'm not sure why those clauses were. It surprised me when I saw those 2 clauses in the RC.
Perhaps we can ask the question differently. Were you in a meeting where this issue was discussed and what was said? I mean,
the issue of the 2 clauses.
Yes.
I was not in a meeting. I was just. I think I picked up following the announcement that the bank went under curatorship, and as we were talking internally, one of my colleagues raised it to say, "Are you aware that these are the 2 clauses that were added into?" That's how I became aware of them.
But perhaps just for clarification, given that it went into curatorship and these clauses had been introduced, what was the impact as a consequence for the PIC?
Well, so when I picked up this and also the fact that the bank went into curatorship, and I clearly, in my mind, I clearly said, you know what, whatever amount that, still it's gone. That's just what came to my mind.
In the essence of it is those 2 clauses removed the protection of the PIC and created everybody else to be, whoever would be ahead of the PIC would be last in line should anything go wrong. And that was the purpose of it.
To manage the risk of conditions approved by the approving committee not filtering through to legal agreements, it was recommended by the internal audit in 2018 that the memo recommending the sign-off of final legal agreement must include the executive heads of affected divisions to agreements, amongst other recommendations. I have attached internal audit report dated April 2018, where such recommendations were made by the internal audit as Annex F to this statement.
Thank you, Mr. Commissioner. That's Mr. Nkwane's evidence.
Through you, Commissioner, what I'm going to say, it's not part of my statement, but I thought it'd be worth mentioning. I think part of the problem, and I think it was spoken to by my previous colleagues, around the system, the IT system. My belief is that although, yes, there are improvements that we can make within our own processes, but what is lacking now is that the proper IT systems that would support our investment process. And my colleagues made reference to a number of things we are doing manually, and which creates a bit of a challenge. And some of these things that have been picked up is purely because we don't have a proper system. But it's also worth noting that we are in a process of implementing a private equity system for unlisted investment. We've went out on a tender process since last year, and we are actually in the process of implementing the project. We expect that before the end of this year, the system would be fully implemented, which will help quite a lot, because as I said, as we speak right now, a number of things within the enlisted division is done manually. I mean, for example, you know, application process. It's one of the problems. At this point in time, you can't really tell how many application processes have we received in the last 2-3 weeks, because you know we don't have proper systems to handle this. To handle the application process. So I think for me, part of the priority is to make sure that we have these IT systems being implemented. The other thing is that that I think we need to improve on is around the handover process. In the previously, the handover process just became just a meeting that lasts 5, 10, 15 minutes, and then we are done. It started to lose the essence of it, in terms of why we needed to a handover meeting. One of the things that we were discussing internally in terms of handover process is to actually invite the investee company or the sponsor to come to that meeting so he can meet the PIC officials face to face. So it's not a handover meeting where it's just the PIC officials only, and then we're reading documents. So it will help also to put a face to the sponsors behind, and colleagues from various units can actually engage directly with the sponsors, rather than just having a meeting where, for example, it's just the PIC official. I think, lastly, Commissioner, I believe the processes, the unlisted investment process, as I've said, have evolved over a period of time. In the last 2, 3, 4, 5 years, if you compare the process now and you compare it with the process 5 years ago, 6 years ago, it has improved significantly. But I believe there are room for improvement, as highlighted with some of these findings, or as people come and give statements. In fact, lastly, I was saying to my colleagues that as part of, I think, helping the Commission coming up with a recommendation, we should probably put a submission just to give context in terms of how we evolved from 2013, 2012, up to where we are now, from whether the governance committees, whether the investment process, whatever the case may be, so that we can also help in terms of helping the Commission put together the recommendation going forward. I'd like to thank the Commissioner.
Yeah, I think so, Judge. You're welcome. I think would like to have that, if you can sort of prepare it and give it to the team. Yeah. submit it to the team.
Thank you, Commissioner.
I take it you signed your statement?
There is an original that's been provided to the Commission, Mr. Commissioner.
Just some clarity. You got two sections in your statement. One is on procurement and the one is on disbursements. Are they linked? I mean, you know, it seems they are two separate concepts.
When I was requested to put my statement was that because if you recall the investment process from obviously receiving application until post the disbursement, with these two key components, I was trying to, and as I was requested to say in the investment process, can we deal with that part where your involvement within the investment process? One of the key our key involvement is on the DD as it relates to procurement. And then one of our key involvement is as it relates to disbursement, because I needed to cover what happened on the disbursement process as it relates to VBS. So I needed to give context to the disbursement process and our involvement in the yeah.
To cover your part in the value chain.
In the value chain, yeah.
Of the whole thing.
Yeah.
Okay. No, I'm clearer now. I'm much clearer. Okay.
Yes, thank you, Mr. Ngwane.
Yes.
Yes, thank you very much, and thanks for your time, and thanks for coming to testify before us. We've learned more about your institution, the PIC, than we knew because of your evidence. But I'm excusing you now, or we are excusing you now. Be ready, though, to come back if and when you are asked to do so, to clear up certain things that we need clearance on. All right.
Thank you,
Commissioner.
Commissioner.
Thank you very much. You're excused.
Thank you.
Mr. Commissioner, it's now 4:15. I'm in a difficult situation. It's been a long day. I have another witness that is ready. I don't know what is the intention of the committee. Till when do you want to sit this afternoon? What we can do, I can inform the Commission that my intention was to present part of this witness evidence this afternoon and the rest after the other witness tomorrow. But I had sight of the statement of the witness that is coming tomorrow, and it would seem to me that he will finish in the morning and that we can then deal with this witness after his testimony, if that is perhaps a more acceptable situation.
So the plan was to have one witness tomorrow.
The plan was to have one witness tomorrow, but it would seem to me that he will finish in the morning, and I understood from the Commission that we can also use the afternoon tomorrow. If all is going to plan, I foresee that we should be finished by about 3 o'clock tomorrow afternoon.
By about 3 o'clock. That's fine. That's fine. So this witness can then come tomorrow sometime?
Yes.
Yes. So we'll then adjourn until tomorrow at 10?
Thank you, Mr. Commissioner.
Yeah, we can carry on until 4 o'clock tomorrow.
Thank you.
If necessary.
Thank you.
We'll adjourn.
iPad? Yes. Can I what? Balance quickly? From when I was,
no, but we are told that they are coming to us now because Heidi is ready. Who's communicating with Heidi? Marilia, Michael is communicating with Heidi to say they are coming to us now. And they are calling. Yeah. Okay, we'll wait for you guys.
Business report pulled it first, eh? Business report pulled it first. About Matsepo More.
Some people said it was fake. Good.
I don't know who said that. Hi?
30 minutes.
We must crossing